super wealthy in Europe and shove the costs of the economic crisis down the throats of workers, the unemployed and the least well-off in European society. While you throw out a few tokens and references to dealing with youth unemployment and growth strategies and so on, the key watchwords that were repeated again at the most recent summit, and which are the actual priorities that are emerging from these summits, are budgetary discipline, economic coordination and increased competitiveness, which translate for ordinary people into more austerity dictated centrally from Europe, and further attacks on the pay and conditions of ordinary workers and attacks on the welfare system, supposedly in order to increase so-called competitiveness. And, of course, putting more power into the hands of the European Central Bank, whose policies, as Deputy Donnelly outlined, have actually worsened the situation of the European financial crash. And just to add to his point, you see, when we bemoan and you bemoan the failure of the banks that we bailed out to deal with the mortgage crisis, to lend to the SME sector, or to behave in any way as if they give a damn about what's happening to ordinary citizens in this economy, you bemoan it, but yet you are moving towards giving more power to the institution that is in fact dictating that policy to our banks. Because as soon as the crash hit at the end of 2007, 2008, the European Central Bank issued guidelines to the banks demanding, and to states, that even if banks were to be rescued with public funds, that they must maintain profit maximisation as their key priority and should be not diverted into other social goals or macroeconomic goals. Very simple, very clear. When Richie Boucher behaves like a belligerent thug, frankly, at Finance Committee meetings, refusing to pay any attention to the interests of public representatives, it is because he is following ECB policy, which says profit maximisation for the banks is the only thing they should care about, and it is clearly the only thing they do care about. And the cost of that is very clear in terms of what's happening in Irish society. Despite all the European of the Year awards, the backslapping and the hugs between leaders at these summits, you are delivering nothing in terms of debt relief, and it's increasingly clear you're not even asking for serious debt write-down. We are getting nothing to deal with the unemployment crisis. Your own medium-term fiscal framework tells us that even if your budget projections work out for the next 2 years, unemployment will only go from the current level of 14.8% by the end of 2015 to 13%. So that's what the unemployed of this country can look forward to, a 2% reduction in unemployment by the end of 2015. In other words, no end to the economic crisis, and in real terms, in the domestic economy, growth continuing to fall. That's nothing to cheer about, Taoiseach.
Okay, your time is up, and
yeah.
You're only eating into Mick Wallace's time, so W. Wallace.
Thank you, Claire. Minister, or Taoiseach and Tánaiste, if you ignore the irreparable social damage that austerity has caused and ignore the destruction of our domestic economy, the test of whether austerity and structural reforms are working, according to those who managed to live out their existence in the financial bubble, is the ability of countries that have received bailouts to return to the capital markets. Now, what does this mean? If it's to mean anything, it must mean that a country can borrow long-term funding from private investors at a sustainable interest rate that roughly resembles what it paid in the past. In 2005, Ireland was able to borrow for 10 years at under 3%. Right now, its notional 10-year borrowing costs are 4.3% today, but might be higher in practice. If we do find ourselves borrowing when we go back to the markets at rates close to double what the stronger countries buy at, we will continue to play catch-up, falling further behind all the time. And if the European Union is to take best care of all its members, there will have to be some form of debt mutualisation. The alternative will leave us permanently on the periphery. Now, it was interesting to read the take of leading Financial Times correspondent Wolfgang Muncho on Monday, when he said, at the European summit, the German Chancellor said she rejected a mutualisation of debt and hidden transfer payments. In other words, she will reject a bank resolution mechanism that does what such a policy is supposed to do, take taxpayers' money and rescue a bank. Without a real resolution mechanism, there can be no banking union either. So what happened last week was the political process stalled in a very big way. What has been agreed last week is virtually cost-free, a single supervisory mechanism for about 2% of the banks in the Eurozone based at the ECB. The common supervisory structure will affect only between 100 and 150 banks out of a total of 6,000, in other words, which is those with assets of more than 30 billion. And as Deputy Martin has pointed out, this 30 billion will become a kind of target to circumvent. The practical outcome of this agreement will be a two-tier banking system, one for large banks and one for small banks. The ECB will deal with failing banks just as the Eurogroup has been dealing with failing states. It will replace existing debt with new debt and impose conditions. And just as the Eurozone will try never to allow one of its members to default, the ECB will never close down a bank, no matter what its problems. Bank resolution thus becomes a euphemism for exactly the opposite. It will be about the pretense of resolution and not real resolution. Now, that guy is pretty well respected, and he's not awful impressed with what went on at the council meeting last week. Now, if we're going to look at the status quo for another, I don't know how long, and if it means that we continue to drive down earnings, continue to undermine the social welfare system here, continue to allow women and children to suffer most from austerity, which we know has happened, then the brainchild of today's austerity, the brainchild of today's version of neoliberal thinking, surely the price of our relentless adherence to the European powers is just a price too high. Thank you.
Deputy, we now move on to questions, and if it's okay, I'll take 3 questions at a time to allow everybody in, if that's fair enough. So, Deputy Mayor Martin.
Thank you, Cathaoirleach. And to put it to the Taoiseach, first of all, in relation to the single supervisory mechanism, would he accept that it is a major disappointment that 98% of banks have been excluded, in essence, as myself and Deputy Wallace have pointed out? And if he could accept that the other key elements of the banking union have been undermined by this decision, and essentially that is in terms of deposit guarantee scheme and in terms of a failed bank resolution mechanism, that both of those have been undermined by this fundamental decision, and that there's huge resistance within Europe, and particularly from the German perspective, to any real banking union that has teeth and that has scale in terms of covering the 6,000 banks. Secondly, if the Minister could confirm, or the Taoiseach, sorry, could confirm that he hasn't attended any meetings with the ECB in terms of negotiating on the promissory note, and if he could indicate, one, does he accept the basic principle that a host country doesn't use the presidency to pursue its own agenda? And secondly, does he accept that the European Council doesn't have jurisdiction over the European Central Bank? And therefore, could he explain to the House how we, as chair of the Council, or as Van Rompuy will chair it, but as co-chair, how we can influence the ECB, given that the Council actually doesn't have jurisdiction over the European Central Bank in relation to resolving the promissory note issue? And if you could explain to the House how exactly we're going to use the EU presidency to advance negotiations with the ECB.
Thank you. Deputy Sean Crowe.
Margaret, in relation to the IMF there during the week had a statement about in relation to the state not meeting its deadlines in relation to it. Was there any sense, and I suppose the subtext was that austerity is clearly not working right across Europe, was there any sense across the European leaders at the Council meeting of this growing reality, and was there any discussions in relation to the actual social cost of austerity and the impact it's actually having on that? Tánaiste, the Taoiseach mentioned in his statement there about there was a meeting in Marrakesh with Minister Costello in relation to Syria, and he invited the opposition coalition. Is there any indication, are they going to take up that invitation in relation to that? There was talk in terms of prior to the meeting of the situation in Palestine, particularly in relation to the proposed new settlements, the 3,000 new settlements. Again, was there any discussion in relation to, was there any agreement around that matter? David Cameron, the British Prime Minister, has come out suggesting that they're considering leaving Europe, and we know that there's a statement due in January in relation to that. Again, as part of the side meetings, or did it actually come up with the thing in relation to his view in relation to that, and the negative impact this would have on Ireland, particularly in the border region, and the difficulties that would have in relation to it. The situation in relation to Deputy Adams had asked the Taoiseach in relation to raise the Silva report into the Pat Finucane killing, and again, did that come up as part of the discussion? Was it raised with the British Prime Minister in relation to that matter? Thank you.
First of all, Deputy Martin's question. It's not a case that 98% of banks are excluded from the single supervisory mechanism. In fact, the single supervisory mechanism will cover the vast majority of European banks. I think some estimates are about 90% all told of banks will be covered. I think the misunderstanding here is that the direct supervision by the ECB will be well. There are a number of categories. There are banks where the assets are more than 30 billion. There is also the agreement that the three largest banks in each member state will be covered. There's also banks which are greater than 20% of their own country's GDP. There are banks which will be in trouble, and they're the ones that have been identified as the banks which will come directly under supervision. Yes, that's right. Yeah, but that's not. No, we're talking about direct. I mean, I think you're missing the point here. The point is that the direct supervision, I mean, the supervisory mechanism will embrace the entire supervisory system of the European banks. Now, I think we need to just stand back from this because, there was a lot of scepticism when, first of all, there were people who said that there wouldn't be agreement at all to separate banks and sovereign debt and to allow for the ESM to recapitalise banks. There were a lot of sceptics about that. There was agreement reached on June that would be done. There were then people who argued that in October that there was going to be a pullback from that. There wasn't. There was a commitment in October that the legislative framework would be put in place by the end of the year. That has now been agreed. The second two elements of the banking union, which is the bank resolution issues and the deposit guarantee scheme issues, they're to be proceeded with in the early part of 2013. So far from being undermining progress on banking union, the progress is actually being made And I think that that is something, first of all, from the point of view of the European banking system, but secondly, because of our own particular interest in the issue, is something that we have to welcome. In relation to the ECB and the discussions with the ECB, again, I think we have to go back to the formula that was agreed in June, which was that the Eurogroup would take that forward, that the Irish financial system, the situation in the Irish financial institutions, that will be addressed on its merits, and as has been clarified by a number of European leaders in the intervening period of time, that is being addressed on the basis that Ireland is a special case. The discussions with the ECB are being conducted in the main by the Irish Central Bank. They are being backed up by political level discussions which are taking place at the Eurogroup and ECOFIN, which are conducted by the Minister for Finance, and secondly at a political level by both the Taoiseach and myself. And that process has been underway for some time. Progress is being made, and as we have said from the very beginning, our objective here is to get the right deal for Ireland, rather than setting ourselves some artificial deadlines, and we're going to. But the ECB is separate. I mean, there is a structure which is established. There is a structure which is established for the ECB.
Do you accept the Council doesn't have jurisdiction?
No. Well, I'm not quite sure what the purpose of your question is. The Council agreed. The Council agreed. The Council agreed the way in which the issue of the Irish bank debt issue was going to be dealt with, and that was that it would be progressed by the Eurozone. It's not. No.
A simple question: does the Council have jurisdiction of the ECB or not? Yes or no? You say yes or no to that.
The issue here is, and it's not about playing politics. No, I mean, the only body playing politics with this now is yourself. The issue here is to secure the best possible outcome for this country in terms of the banking difficulties that we have. I don't want to go back into. I mean, if you invite me to play politics, we will trace. I'm quite happy.
No, because there are other questions to be answered as well. In fairness,
I am quite happy. I'm quite happy to trade. You keep this interrupting pattern.
Please.
If you answer the question, yes or no, we'll be over here.
Please.
I'm answering your question. I'm answering the question. I'm answering the questions you asked. You asked questions about the discussions.
Through the chair.
You asked questions through the chair. You asked questions about the discussions with the ECB, and I'm providing you with the answer.
I basically asked you, does the European Council have jurisdiction?
No, that is not. No, that is not the question. I wrote down the question that you asked.
The various leaders, the Taoiseachs and leaders have had an opportunity to take up the majority of the time of this debate. There are a few of us here to ask questions.
So, right, Taoiseach, just respond to the question. Particularly Deputy Crowe.
Well, I've answered Deputy Martin's question. Deputy Crowe's question, in relation to the social cost of what has happened to the European economy. The social cost is addressed in the conclusions, and the conclusions of the European Council last week clearly state that what is being addressed is both the economic and the social dimensions of this. I think that the resolution of Europe's economic difficulties and the debate around that, I think, has moved on, and it has moved very much on to address the issue of what is needed to generate economic growth in Europe and to ensure that there are jobs created in Europe. And that's why the priorities for the Irish presidency in the first half of next year emphasise growth and jobs, and set out in our programme the way in which those issues are to be addressed by completion of the single market, by addressing the digital single market, by addressing issues of mobility in the labour market, and indeed by the banking union issue, and by the promotion of trade agreements, all of which are aimed at developing an environment where jobs will be created in Europe. In addition to that, it is also our intention to advance the proposals for addressing youth unemployment. Levels of youth unemployment in Europe are far too high, and that is why we have given a very high priority to getting agreement on the youth guarantee during the course of the Irish presidency. In relation to Syria, as you indicated, Minister of State Costello did suggest that we would invite the new Syrian coalition, the opposition coalition, and we will be doing that to have discussions with us. I did meet Mr. Khatib at the Foreign Affairs Council at the beginning of last week, and I hope to have the opportunity of meeting him here in Ireland if that can be arranged. A very clear conclusion was reached in relation to the settlements. Very strong statement was made about the building of the settlements on the West Bank. It is our view, and we've stated it repeatedly, that the building of the settlements in the West Bank will make a two-state solution impossible. On the Taoiseach has discussed the De Silva report with the British Prime Minister, and I've discussed it with the Secretary of State for Northern Ireland and with the Deputy Prime Minister, and it is something that we expect we will be discussing again with them.
Okay, thank you, Taoiseach. Now, Richard Bradbar, Deputy Richard Bradbar.
Taoiseach, two questions. First of all,
where the time is moving on. We get to 3 questions, so that's brief.
Yeah, don't worry, I won't take as long as Deputy Mark. Don't worry, I won't do that. 2 questions. The development of the banking union and supervision of the banks by the ECB is being presented as a sort of panacea that we should look forward to. Now, my question is this: why is that being presented as some sort of positive development when the ECB, by any reasonable sort of assessment of what has gone on, bears an enormous responsibility for the failure of the banking system and the financial system in Europe, and that many of its decisions have worsened that situation, and its priorities seem to be entirely at odds with the concerns of ordinary citizens in terms of, because ordinary citizens, and presumably their public representatives, at least at a public level, are saying what we need is jobs, we need economic growth, we need a path out of recession. The ECB's priorities are none of those things. They're about book balancing, they're about profit maximisation for the banks, they're about an insistence that in fact public authorities don't interfere with banks when we need more interference, judging from what has happened and what is happening. So that's the first question. Why is this being presented as some sort of positive development? And what assurances can you give us that the ECB, having this level of power over the banking system, is going to improve the situation in any way? Secondly, about 2 weeks before the latest council, the biggest general strike in European history, in fact I think in world history, took place. Much as the government sometimes like to blame me and certain people on the left for protest, you can't blame this one on us. This was an unprecedented, coordinated, European-wide mobilisation of working people, of the less well-off, of their civil society and trade union organisations saying, this is not working for us. For ordinary people, it's just not working. It's not dealing with unemployment, it's not producing economic growth, it's impoverishing us. And we want an end to these policies.
Deputy.
And our own unions are planning to do something in early New Year. What can you say to them, Taoiseach? In what sense is there anything coming out of this summit that offers them anything? When, as I asked earlier on, and I finish on this, Caroline, your own medium-term fiscal outlook says that unemployment will go from 14.8% this year to, by the end of 2015, 13%. Okay. So the promise is that we will get less than a 2% reduction in unemployment. What does that offer us?
Okay, that's the question. Deputy Peter Matthews.
Mr. Chair, we're running down on time. I'd like to ask the Taoiseach and the Taoiseach to make particular note, this is my question, I want you to make particular note of all the 4 aspects of the contribution that Stephen Donnelly, Deputy Stephen Donnelly, made about 20 minutes ago. He mentioned the ECB and its incompetence at various stages to date. He raised the question of the adequacy of the banking union and what it is there to do. And as Mick Wallace developed, and correctly so by reference to Munchau's article, that what has been envisaged in the banking union could fall very far short of what's needed. And rather than the political plastering over of the situation, it's a bit like what's happened in recent times is like there has been large deluges of financial rain and the system has surcharged and then it's abated. And it's not gone away, and the fundamental engineering of the banking system of 6,000 banks in the Eurozone is still hugely weak, and it hasn't been addressed. Deutsche Bank, and I think I gave you, or I gave the Taoiseach an article only about 2 weeks ago on Deutsche Bank, which by the admission of very senior people in Deutsche Bank, there had been an accounting fraud at a level of maybe up to 12 billion at the height of the financial crisis. These banking institutions are quite fragile. They've been plastering over their own fundamental engineering weaknesses. And it's time now that we can actually, as president of the union next 6 months, we can actually bring these right up to the top of the discussion. And we should do it. And we should do it also mindful of what Stephen Donnelly said in his last point, which is we should be careful that all the visitors see the comforts, the natural comforts of hospitality when they're here, and will not be aware of the households 1 in 4 mortgages in distress. And they need to get tutorials about this when they're here, because we will not be in a position to add weight to the argument, to add justification to the case that we need the right dose of financial antibiotics, not a small dose that will fail and will allow the body relapse into economic underperformance. We need a big cortisone injection, and that's a big write-down, big one. Nothing less will suffice.
Okay, thank you, Deputy. I now call upon the Taoiseach. Will you answer the questions and also your final statement as well, maybe?
Thanks, Cathaoirleach. Well, I think Deputy Boyd-Barrett, I think questions get to the heart of what this is all about. This question about why do we say that banking union is a positive, and how does that relate to the imperative to create jobs and get economic growth in the European economy. And if you think back on where we were with the banking crisis, Deputy Martin will remember it, doesn't want to be reminded of it, of course, but it essentially was at the start of the banking crisis. What happened here was that the state took responsibility. The state gave the guarantee, took on the debts of the banks, and put the debts of the banks on the shoulders of the taxpayer. And the European position, the ECB position, through all of that, was that that was the way to go. That your banks, Ireland's banks' problems, is the problem of the Irish state. The Spanish banks' problems is the problem of the Spanish state, and so on. And if something goes wrong in your banking system, that's your problem. You're on your own, and you do it our way. Now, what has changed? What has
the liquidity crisis, which it wasn't.
What has changed? What has changed is that fundamental view of the banking crisis has now changed. There is a change in European policy in relation to banking. And that change is expressed in the conclusions of the June summit, which clearly stated that banks, the bank debt and sovereign debt were to be separated, and that Europe would proceed with the establishment of a banking union, which would provide for, once the single supervisory mechanism was put in place, for recapitalisation of banks to be done through the ESM. In other words, where we have moved from a situation where individual countries' bank problems were their own taxpayers' problems to a situation where the problems of banks within the Eurozone system are essentially a European problem. And that's why banking union is being established, and that's why it's a positive. Where does that relate to the imperative to create jobs and growth? Because if you need to have in Europe a functioning banking system in order to underpin economic activity and to ensure that credit is made available to businesses who create jobs and who generate the economic growth. So the two are very much intertwined. In relation to the points raised by Deputy Matthews, I want to say, first of all, that any of the contributions that are made here by any deputy, of course, are listened to and taken seriously on board. To be honest, if I can follow the analogy, we're gone beyond antibiotics. This is a problem. The problem in the European economy and the problem in the European banking system is not one that can be dealt with by prescribing antibiotics for. This requires, or even cortisone. This is a problem that requires surgery, and it is that surgery which is now underway, because that is why it has to be. That is why it has to be.
Please.
That is why it has to be. That is why.
We're actually gone over time. So
that is why it has to be. It has to be addressed in the way that we're doing it. And I think it is fortunate that Ireland will be assuming the presidency of the European Union at the very time when the issue of banking union is now coming to fruition, because it does give us an opportunity, first of all, of driving forward that process and using the position that we have in the Council to drive forward the process and the implementation of what has already been agreed. And secondly, it also gives us the opportunity of putting very much centre stage the issues that we have ourselves in relation to bank debt that have to be dealt with and have to be resolved. You're just talking it down, Deputy Martin. You're just talking it. Yeah, you're a bit of, I mean.
Please, just allow him to finish. I'm just allowing you. You've only a minute and a half left now, so.
Yeah, well, I mean, Deputy Martin seems to wish that the government would fail in this. Frankly, I think, I think if we think back, this must be the first time that the leader of the opposition in the House, this is the 7th Irish presidency of the European Union. It must be the first time in that period, over all of those presidencies, that the leader of the opposition would effectively be coming in here and effectively wishing that the country would not be able to deliver, or that we would not be able, to develop our presidency. I'm not being dishonest, but you're constantly. You're
Labour's way, Frankfurt's way.
No, you're constantly
overstating. Don't overstate things, Tom. It's a bit like child benefit. People have had enough.
You're the man that came in and said you wanted to put an end to Punch and Judy politics. I mean, if you carried it on like that on the Punch and Judy stage, the children will get tired of it and go home.
I think that concludes the statements on European Council meeting in Brussels. So, thank you very much. We now move on to the Appropriation Bill 2012, and I'll call on Minister Brendan Houghton to move.
I formally move.
Right. The question that the bill is hereby read a second time, that sections 1 to 2. To put the question in accordance with the order of the House, is that agreed? Agreed. Right. That the bill is hereby read a second time, that section 1 to 4 inclusive, schedules 1 and 2 and the title are hereby agreed to in committee, and the bill is accordingly reported to the Houses without amendment. That fourth stage is hereby complete and the bill is hereby passed. Is that agreed? Agreed. The question is agreed. Yeah, the question agreed. The bill, which is certified to be a money bill, will now be sent to the Senate. Thank you. On to the National Vetting Bureau Bill 2012, the amendments. There's amendments from the Shannon. So I move that the amendments be made. Amendment number 1, and the question is.
Yeah, the question is that the Shannon amendment be agreed to.
And this, where's it there? Amendment be agreed to. Is that agreed? Agreed. Right. What do I do? Amendment 2. Amendment number 2, and that the amendment number 2 from the Shannon, that the Shannon amendment be agreed to. Is that agreed? Agreed. Right. Both those are agreed. The Shannon amendment is reported to the House. A message will be sent to Shannon Ayrton acquainting it accordingly. So we'll now move. We're just starting it.
Oh, yes, fine.
Yeah, we're just starting. So, Minister, do you want to make a statement?
Yeah, there's just the one amendment that's before the House that's, sorry, two amendments that's before the House in relation to the vetting bill with regard to, yes, there are two, of course, with regard to the Senate. The first one deals with the Chief Bureau Officer, who's to periodically report directly to the Garda Commissioner in relation to the performance and management of the functions of the Bureau. So I formally propose that. The amendment is in page 24 between lines 40 and 41, and it inserts a new subsection 2. Now, the purpose of this amendment is to make it clear in the bill that the Chief Bureau Officer shall report to the Garda Commissioner in relation to the performance and management of the Bureau and in relation to any issues arising. Section 23 of the bill already provides that the Bureau will make an annual report via the Garda Commissioner to the Minister, which will be laid before the House of the Oireachtas. However, the bill should also provide that if in the course of any year there are urgent issues which the Chief Bureau Officer needs to bring to the Commissioner's attention, he or she may do so. And I want to, in the context of this, say that it's important, in my view, that there is a direct reporting relationship between the Chief Bureau Officer and the Commissioner for a whole range of reasons. For example, if it turns out that the amount of work that the Bureau has to undertake as a consequence of the implementation of the bill is putting it under pressure. If there are staffing issues, it's important that this is something that can be directly, immediately reported to the Commissioner and reported to my department insofar as there's assistance that we can give in these matters, or, for example, some technical difficulty arose in the working of the new legislation. I don't want it to have to go through different levels within the Garda Síochána without that being, I think, without that being, before that was communicated to us. I think it's important communications occur at speed. So it's an amendment which ensures that the office can operate in a manner that's efficient and communications take place efficiently.
Are you okay? Are you happy with that? So, what's next?
Yeah.
They have already been agreed. But
okay. Yeah. Well, the second amendment deals with reception or accommodation centres, which provide residential accommodation services to applicants for asylum. And in retrospect, we thought that we should include those within the bill for vetting purposes. It's worth putting on the record of the House, though, that my department's contracts with persons or organisations who provide accommodation for asylum applicants already require that persons working in these accommodation centres are vetted. However, I think it is appropriate to make this a requirement in law rather than solely to rely on administrative arrangements. This amendment therefore makes it clear that the vetting of persons who work in such accommodation centres is a legal requirement. And if I could, Chairman, just conclude and say a few words in relation to this bill briefly. I want to start off by paying tribute to those working in what is now going to be referred to as the National Vetting Bureau. I think they do extraordinary work extremely efficiently. And I think I'd like to pay tribute to the head of the Bureau. I'd like to pay tribute to the head of the Bureau, Superintendent Pat Burke, who I think works beyond the code of duty in the hours he puts in the very efficient way in which he coordinates the work of the Bureau, in the manner in which he tries to facilitate circumstances of individuals and organisations where a vetting is required at speed for some particular reason. And I think it's important in completing the bill that we acknowledge that work. Finally, I do want to say, Chairman, that the enactment of this bill is a very important marker and a very important change effected by government. It was part of the programme for government that this legislation be enacted. A vetting legislation which facilitated the use of soft information was promised for many years by previous governments and wasn't enacted, wasn't presented to the House. Back in the over 10 years ago now, I think, or in the region of 10 years ago, a previous government suggested there were constitutional difficulties in progressing this legislation. There were at least 2 private members' bills published in this area, is my recollection, by members of my own party, the Fine Gael party, during that period. And ultimately, the committee, the Joint Oireachtas Committee on the Constitutional Amendment relating to children, reported on this issue. And in September 2008, published a report which said there were not constitutional difficulties, which the then government finally accepted, and recommended to the previous government that legislation be urgently published and enacted, and no such legislation was published during the lifetime of the previous government. So the enactment of this legislation marks a very important step in putting in place an additional protection, both for children and for vulnerable adults, against the possibility of abuse. It seeks to ensure that those who are employed in these areas, either professionally or those who engage voluntarily on a regular basis in these areas, are properly vetted, and that the vetting now includes not merely accessing criminal convictions, but goes to using appropriate soft information, but in circumstances in which the individual rights of those who may be affected are protected. They have an opportunity to know what information is being relied upon, and indeed there's an appellate structure within the framework of the legislation to ensure that if information is incorrect, that issue can be addressed within a fair and appropriate framework. So it is an important day that we're enacting this piece of legislation. I think it's right that we acknowledge its importance. I want to say to members of the House, there are statutory instruments to be made to bring the legislation into force. It's my objective that we bring it into force in the first quarter of next year. I've no doubt that it's going to impose additional burdens on the Vetting Bureau. We're looking to address any staffing issues that arise to ensure that the staffing within the Bureau is appropriate to meet the demands that may be there. It's important that those groups, organisations, businesses that are required under law now to engage in vetting fulfil and meet their obligations in that context. We have to remember that what was there previously in a number of was substantially a non-statutory scheme without penalties for non-compliance. And there are now penalties for non-compliance, and it's important that there is compliance. It's important that we have in place a legal architecture that provides the maximum possible protection for children. No government can guarantee at any time that no child will ever be the victim of abuse. As much as we would like to live in that utopian world, we don't live in that utopian world. What we can do is put together a legal framework or architecture which creates the possibility of protections for children, which tries to ensure that children aren't placed at risk in circumstances where the risks should have been previously identified. And effectively, we adopt what I describe as a precautionary approach. And this bill is another brick in the wall to establish that, and I want to thank members of the House for their cooperation in the enactment of the bill. I'd also like to, if I could, thank David Stanton, who's chairman of the Joint Oireachtas Justice and Defence Committee, and all the members of that committee for the substantial work they did when we published the heads of the bill and for their comments on the bill. And I'd like to thank the various individuals and organisations who made submissions, not just to that committee but to my department, so as to ensure that we enacted the best possible piece of legislation. So I think it's important, Chairman, to conclude on that note. And again, I want to thank the deputies opposite their parties for the constructive contribution made throughout the debate on this bill in both houses.
Okay, Minister, thank you very much.
Sorry, Chairman, I should also add that I want to thank the officials in my department for the very substantial work that they've engaged in and for their assistance in ensuring that we achieved our objective of having the legislation enacted before the end of the year.
Certainly haven't forgot anybody. So, yeah, now we've agreement to the Shannon. So,
can I make some comments, please, on this? Can I comment on this too?
Okay.
Okay, thanks, Chairman. Just to thank the Minister and his department officials for your cooperation and taking on board some of our feedback throughout the process, and that's very much appreciated. This is obviously a very, very important piece of legislation, particularly in the context of the passing of the children's referendum and, you know, the belated I suppose, accepting of responsibility by state in relation to these matters. We still have a long way to go, but this is definitely a step in the right direction and a reassurance to the public that lessons are being learnt. One issue that I want to raise, Minister, is the issue of spent convictions. I just ask you to further consider this matter and to maybe review how this is progressing in time. You wrote to me back in October, and what you said was that it was your intention to streamline the interface between the two bills to ensure that they work together harmoniously. Now, obviously, we need to, you know, move forward with the spent convictions bill in the year ahead in 2013, and when we're dealing with that legislation, you know, there are inevitable issues. Now, I read the transcript of your exchange with my colleague, Senator Trevor O'Claherty, and I see in the transcript you do acknowledge this is a very difficult balancing act between protecting the interests of children, and obviously that includes soft convictions. You know, we in Sinn Féin support that because the main priority is the protection of children in all of this. But whenever we're going through the spent convictions bill and process and engaging on that, there may be issues to reconsider again. There may be an opportunity to look to see, can we dovetail both and ensure the maximum protections. Again, I'd ask you to look at that. I did see from your exchange that it was something you are reflecting on and will continue to reflect on. So I just wanted to sort of raise that at this point and to ask you, when we commence the next process that is somewhat related to this, that you would you know, consider that again. Okay.
Okay, Deputy Collins, okay. So if that's all right, we're happy to move on. Then agreement to Shannon amendments is reported to the House. A message will be sent to Shannon Aaron, acquainting it accordingly. Okay. Yeah, F1. Yeah. So, right, we're moving on to the Personal Insolvency Bill amendments from the Shannon. First amendment, I read 147, 8, 9, 53, 70, 72, 74, 91, 94, 95, 106, 109, 125, 145, 148, 149, 155, 164, 172 to 175 inclusive, and 181 are related and will be discussed together. I now call on the Minister.
I welcome the opportunity to return to the House to report on further amendments made to the bill in Shannon Éireann. A total of 245 amendments were proposed and approved during committee and report stages of the bill in the Shannon. These were all government amendments and were for the most part technical changes or text corrections. The long title of the bill was amended to take account of the insertion of new provisions in Part 5 concerning the regulation of personal insolvency practitioners and the insertion of a new Part 6 concerning the appointment of specialist judges of the Circuit Court to deal with personal insolvency. I should also mention that amongst the amendments approved by the Seanad were those in regard to the exemption of one item of personal jewellery to the value of €750 and an increase in the value of an exempted motor vehicle from €1,200 to €2,000 in the debt relief notice process. Changes also along these lines had been advocated by Senators Byrne and Cullinan in particular during the second stage Seanad debate. The new section concerning the development by the Insolvency Service of guidelines on reasonable standard of living and reasonable living expenses for debtors is also influenced by the contributions to the debate made by Senators, in particular Senator Zapponi, and I'm very pleased to report that progress. I was also pleased to make amendments to the text at committee stage in regard to the treatment of goods on hire purchase in the debt relief notice process. These were on foot of comments made by Senator Norris during second stage. For ease of reference and to facilitate the debate, I am proposing to group the amendments thematically. This is because a number of amendments are necessarily repeated throughout the bill to ensure a consistency of approach in relation to each of the new debt resolution processes, and in some cases are also replicated in the part dealing with bankruptcy. The Cathaoirleach has already read out the various amendments that we're taking together, and I'd like to turn specifically to those amendments. The purpose of these amendments is to either improve the presentation of the bill for greater clarity or to correct drafting errors in the text. Amendments number 173, 174, 175 are drafting amendments designed to allow for service of notices by ordinary prepaid letter rather than by registered prepaid letter as currently required by section 129. This change has been suggested by legal practitioners to address difficulties in using registered post effectively. It's the experience of many solicitors that up to 50% of this post is not delivered. The single largest reason is, and I quote, "not called for," which is written on the envelope. Other reasons include refused, gone away, and I think on occasions include certain obscenities, which I have no intention of giving voice to in this House. Not everyone is enthusiastic when they received something by way of registered post. Ex parte applications, which would otherwise have to take place, are expensive and time-consuming to follow up on. In Northern Ireland, the service of documents is now conducted via first-class post, and we think it's appropriate that the amendments be made with regard to dealing with ordinary post.
Just to comment in relation to some of the items you mentioned there, I take on board what you have done in relation to jewellery, and I think that was well aired during the previous stages when we took it in the House here. I think in relation to the value of the motor vehicle, that is a welcome amendment, and I think what we said at the time was that people should be allowed retain a motor vehicle which was appropriate to the family or the individual person's needs, and I think in fairness increasing the value from 1,200 to 2,000 will go a long way towards addressing that issue. You know, so many people rely on obviously vehicular transport. It's not a luxury, it's a necessity for most people, and I think the fact that you've increased the ceiling by a significant amount will go a long way towards meeting it. Just in relation, you mentioned in your few words there in relation to the appointment of specialist judges. Has that been taken as part of this group of, you know, that's the specialist judges to the, is that in the next grouping?
Yeah, just to clarify, 7 that were.
Pardon?
Is it included in these amendments? Yeah, no, it's not included in these amendments. I was just making some opening comments. But when we come to the 7th group of amendments, we're dealing specifically then with specialist judges. But I was just making an opening comment.
All right, okay. Okay. Well, I can confine it to that, sir. Thanks.
Okay, so you want to, will I put the question on?
Yes.
Yeah, that the Shannon amendments be agreed to. Is that agreed? Agreed. Right, we'll move on to the Shannon amendment number 2. So we take 2, 12 and 22 inclusive. Is that right? Inclusive and 24 are related and will be discussed together.
I so move. That's 212, 222 and inclusive, and also Amendment 24. These amendments relate to the organisation, functions and governance of the Insolvency Service itself. The Insolvency Service, in operating the new debt relief notice, the debt settlement arrangement, the personal insolvency arrangement, will, for maximum effectiveness and efficiency, operate on a paperless basis to the greatest extent possible, with electronic completion and transmission of documents. The court involved will also receive and issue documents by electronic means in order to facilitate the efficient deployment of staff and court time. Amendment number 2 inserts the definition of electronic means. The definition is required as a result of the proposed new section 23 at amendment number 24, which provides for the Insolvency Service to communicate by electronic means and is designed to facilitate the processing of documents by the Insolvency Service and the Court Service in regard to applications for the various debt resolution arrangements provided for in the bill. Amendment 12 deletes section 8, subsection 2b and c, as they are not necessary for the purpose of the operation of the Insolvency Service, as it would not be owning or holding property in its own name. The OPW will effectively be making the necessary office accommodation arrangements for the service. Amendment 13 is intended to make it clear that it should be the Director of the Service rather than the Insolvency Service itself who authorises a person to enter into contracts on behalf of the Insolvency Service. Amendment number 14 improves and extends the functions of the Insolvency Service by now including a reference to use of the reasonable expenses guidelines and also to education and training. Amendment 15 provides for the term of office of the Director of the Service, of the Insolvency Service. Amendment 16 addresses the current wording of section 11, subsection 3, which may not fully reflect the reporting relationship within the Insolvency Service in regard to who will be making the policies and decisions of the service and that the Director will implement. I'm advised that subsection 3a is not required in the context of the Insolvency Service and should accordingly be deleted. Amendment 17 amends the text of section 11, subsection 11a, to delete the reference to disqualification, which is not appropriate in this particular context. Amendment 18 makes it clear that the 5-year tenure of the first Director of the Insolvency Service, where he was previously appointed as Director Designate, commences on the date of his initial appointment to the Director Designate post and not on the establishment date of the service. The bill, as passed by the Dáil, does not adequately deal with this particular matter. Amendment 19 seeks to replace the existing section 15 of the bill relating to a business plan with new text. The proposed new text retains the requirement for the service to submit its business plans to the Minister for approval every year. However, it removes the current requirement in the bill for the business plans to be laid before the House of the Oireachtas. Having reviewed the matter, I believe this latter onerous requirement is not particularly necessary. The proposed amendment brings the Insolvency Service more in line with governance provisions of other similar entities. It's very important, however, to note that the proposed amendment does not in any way diminish the accountability provisions of the service to the Oireachtas. These are contained in the provisions of the bill regarding strategic planning, which is section 14, reporting, section 16, accounts and auditing, section 17, and appearances before Oireachtas committees, section 18 and 19. Essentially, for example, in practice, the Joint Oireachtas Justice Committee would be entitled to invite the Director of the Service to appear before it to discuss any issue that fell within the ambit of the Insolvency Service, obviously in a general way, if they saw fit, not about a particular individual's personal insolvency, which clearly wouldn't be appropriate to be a focus of a discussion in an Oireachtas committee, but on general policy issues, capacity of the agency to undertake its task, etc. There's a whole range of issues which I could envisage would arise. Amendment number 20 is a technical drafting amendment and makes clear that the report referred to in subsection 6 is the annual report of the Insolvency Service, which is to be laid before both Houses of the Oireachtas. Amendment 21 proposed the insertion of a new subsection 8 and is linked to the previous amendment to subsection